Good morning, everybody. Thanks ever so much for joining us this morning. It looks like most people are here, although we may still get some people joining us as we start, but we will kick off. My name is Alice Reeve, and I'm joined today by my colleague, Bob Frey. Um, we're going to run through some developments that are on the horizon in relation to employment law. It's a bit frustrating being an employment lawyer at the moment, probably being a HR practitioner as well. We're seeing lots of announcements about things that are proposed. We then see at least one consultation, sometimes more than one consultation, and then it seems to get stuck in the parliamentary process. And unusually, we're then seeing things progressing, often promoted by private members who are pushing things through, who are then backed by the government. So actually, it's really hard to keep track of what's going to happen and when. So the aim of today really is to give a high level run through of some of the things that are on the horizon, just to make sure that you've got them on your radar. You know how it's going to impact on your organisation. If we do know when they're likely to happen, some sense of timing as well. So the kinds of things we're going to cover, I'm going to start off looking at some of the new family related rights, touch on flexible working, and then hand over to Bob, who's going to look at the future of non-compete clauses and then some interesting cases. Please do put any questions that you've got in the Q&A box, and we'll have plenty of time at the end to answer them. So starting off with the first family-related right that we wanted to mention is this new additional right to time off and pay, where parents have the need for neonatal care for a newborn baby. This is where babies are born prematurely or have medical or palliative care needs in the very early days of their life, and it's been identified that that can take an extended period of time, which either eats into current parental leave rights such as maternity or paternity, shared parental leave, and can put a real strain on families as well. Bliss carried out a survey, and they said that actually fathers who don't necessarily have the right time off. 36% of them had gone off ill and managed it through sickness absence when they needed to support their newborn with neonatal care, and 11% had actually opted to leave their jobs to manage the juggle. So this is designed to help parents in that situation. It will give both parents who are eligible and qualify up to potentially up to 12 weeks leave and pay if they've got 6 months service. It will apply where there's a newborn who within 28 days of being born needs to have some neonatal care, so extra medical care for at least a 7-day period. Because of the way family leave works, it's interesting in that although this relates to the early days after they're born, that's what triggers the entitlement, but it's unlikely that that's when individuals will take it, because maternity leave, for example, is triggered when a baby is born. It's got to start then. Paternity leave's got to be taken within 56 days of the birth. So actually, the law isn't going to change those provisions, but what it will mean is that when this right is triggered, individuals will have to let employers know, but that's going to be a very high level notice, just a simple notification to say that their child's in neonatal care. And then they will have a more formal notice requirement when they actually take it, which is likely to be towards the end, in fact, of the other leave period, be that maternity or shared parental leave or paternity leave as well. It will provide quite a significant extension if you imagine that a mum might be off for 52 weeks at the moment and then has got another 12 weeks on top of that. So as an employer, you will obviously need to think about managing that period of absence, and it will certainly mean that we'll have to review the wording in fixed term maternity cover contracts to make sure that there's some flexibility if this extended period of leave is needed. In terms of when it's going to come in, well, we're going to be saying that's the $1 million question for lots of these updates. The government have said This change alone is likely to need 8 sets of statutory instrument, 8 regulations, just to make it easy for us all to follow and keep track, and so that it's unlikely to take effect before April 2025. So we're anticipating that it will come into force April 2025. So it should be on your radar, but not as a priority. You'll obviously need at the time to have a policy around it and also think how it interacts with your other policies. And you might want to be mindful of it if you're reviewing any enhanced rights. So if you're looking at enhancing your family friendly rights for maternity or paternity pay or shared parental pay, I suppose just bear in mind that this is on the horizon and there may be pressure, or you might want to think about whether you would offer enhanced contractual neonatal care pay as well, rather than just the statutory provision. The next right that I just wanted to touch on also relates to pregnancy, and this is the Protection from Redundancy, Pregnancy and Family Leave Act. You're probably all aware at the moment that there is specific regulation that protects individual employees who are on maternity leave if there is a redundancy situation, and gives them priority to be offered any suitable alternative employment as an alternative to redundancy. So the way in which that works is, let's say you had a department of 5 and you're closing that down. If there was a suitable alternative vacancy, if one of those 5 individuals was on maternity leave, they would be entitled to be offered that position ahead of the others who were redundant. It's one of the few examples that we've got in UK law at the moment where there's some positive discrimination angle, but it's intended very much to level the playing field. There's quite a lot of statistics around how much discriminatory treatment women who are on maternity leave suffer from, and many lose their jobs as a result or made redundant as a result of taking maternity leave. So it's been identified that the existing framework, although it offers some protection to those on maternity leave, needed to be extended. And so we are going to see this extended. So the current right will be extended. So as soon as an employee tells you that they are pregnant, this regulation will kick in, so that if there's a redundancy situation, they're entitled to the priority for their suitable alternative job. And it will run from as soon as they've told you all the way through their maternity leave and for 6 months after the end of their maternity leave period. So you will need to be mindful of that. You will need to be careful if individuals are just, tell their line managers, or potentially just tell somebody at work casually rather than putting in a formal notice. That's likely to trigger this requirement, but we're not sure. Obviously, when you're planning redundancy processes, you always need to think about who are those employees in the pool. Are any on maternity or leave or likely to go on maternity leave, because they'll be protected, and you need to factor that in to your planning process as well. There are some other potential extensions of the regulations that we may see that have been proposed, but it's unclear whether the new law will apply to it or not. It will depend on secondary regulations coming into force. And that at the moment, this right particularly protects people on maternity leave, but whether it will also extend to shared parental leave or paternity leave as well. It's also proposed that it will extend to women who suffer miscarriages, so they will have this additional protection. So this one is still slightly up in the air as to when it's likely to come in. Certainly, I think it will happen, but we haven't got the regulations yet in force. So just want to keep an eye on. The next one I wanted to mention was the Carers Leave Act. This is an act that has now received royal assent, but it will give everybody, without any qualifying period, all employees, a statutory right of up to 1 week's unpaid leave per year. So that looks like it'll be able to be taken either in blocks of days or a whole week, or partially, depending on when and how individuals need it. And it's specifically for those with caring responsibilities. That could be to make arrangements for looking at care homes even, or fulfilling those caring responsibilities. is an unpaid right. So like many of the other unpaid rights that we see, it will be interesting to see if there's much take up. We don't generally see much take up of unpaid rights, but this will perhaps alleviate stresses for individuals where they are finding that they've got responsibilities that they're struggling to manage alongside work. This will give them a right to time off, and they'll be protected from being subjected to any detriment or being dismissed as a result. So again, the extension of those detriment provisions, just thinking about promotions, training opportunities, you'll need to be careful not to detriment those who've taken time off for caring responsibilities. It's likely that we'll see this implemented, well, they say not before April 2024, so we might see it on the statute books next April. The next one of this raft of family friendly link to that I wanted to mention is flexible working. Now, this is obviously one of the more significant changes. It's higher profile. We've seen a lot of press around this. The Employment Relations Flexible Working Act has now received royal assent, and so we are expecting this to come into force next summer. So I think you can start planning for that. And certainly on the back of the profile that we've seen in this area and the forthcoming changes, we've seen employees and unions pushing perhaps a bit further on flexible working decisions. And so I think it is an area where we're going to see a rise. And so you should definitely look at your own policies, check they're up to date at the moment. They'll obviously need to be updated in due course, but also it might be an area where you think about line manager training, and you need to think about consistency of approach across your workplace as well, and perhaps just challenging some of those assumptions or decisions that have become slightly entrenched perhaps in your workplace. So what are the changes going to be? Well, there are a number of changes. You're probably aware that at the moment an individual can only make one formal flexible working request in a 12-month period. That's going to be extended to 2 requests, which might feel quite onerous when you've only just finished one to receive another. So linked to that, at the moment, you have 3 months from someone submitting a request to the end of an appeal process to deal with that request. But this will be it'll be shortened to a 2-month period. So you may have 2 lots of 2 months during a year when you're dealing with a flexible working request. And there's a statutory provision that requires employers to consult with staff before rejecting requests. At the moment, that's good practice and it's included in the ACAS guidance. And so we would absolutely always recommend that you do that, that you had a meeting with individuals to discuss it. And if you couldn't accommodate it, explain why and look at alternatives. But it's likely that that will be a statutory provision. The other thing that's going to change is that at the moment, individuals have got to fill in a form or make a request and say what they're requesting, but what they consider the impact of on the organisation will be. I find that really useful because I think it makes employees have a think about what it is they're asking for and how it might be managed. During the consultation, it was felt that it wasn't for employees to think about that actually it was for employers who would understand the impact on the organisation and how it might be overcome more. And so that's going to go, which I think is a bit of a shame, really. What isn't changing is that this is still only a right to make a request, that you will still be able to reject it, and those 8 prescribed business grounds are remaining unchanged. So you'll be able to continue to identify the grounds to reject the request and do so as you have. One of the things that we've seen highlighted is, at the moment, you need 26 weeks service in order to make a flexible working request. We've seen quite a lot of consultation around that, whether it should be from adverts. But in fact, the government have confirmed that although it's not currently in the Act, we will see secondary legislation, which means that the right to flexible working will become a day one right. So that's going to be challenging in workplaces. Potentially, you've got a full-time need, you've advertised for a full-time job, somebody comes in and on day one potentially says, actually, this isn't working for me. Can I start later? Can I reduce my days to 4 a week? And you'll need to consider that in accordance with the process as well. So we've got the Act. We'll see some supporting regulations, and we've also got a statutory code of practice that tribunals will have regard to. ACAS have published their code of practice, and the consultation is just closed actually on the 6th of September. So we're beginning to see the law take shape in relation to this, so you can begin to plan for it and think about what it means for your organisation from summer next year. And the final one that I wanted to mention is the sort of converse to requesting flexible working, and it is the right to request predictable terms and conditions of employment. This has been bubbling away for some time. We don't know when it's going to come into force, but the government have said that it's backing the bill, and this will give individuals who have got 26 weeks service, it doesn't look like that's going to change, the right to ask for a more predictable working pattern, be that length or be more predictable shifts or hours of work. So it's intended to provide protection for those who are on 0-hour contracts or variable hour contracts, or even potentially annualized hour contracts, or a succession of fixed term contracts even. And it's understood that those individuals often have no surety about the hours that they're going to be offered, and obviously the pay, and it's intended to give them a right to ask for those. The law, the regulations will follow in very close fashion the flexible working. So an individual will make an application, there will be a meeting, and you've got to deal with it within a month though, and you can turn it down on the same 8 prescribed business grounds if you want, if you don't feel that you're able to do it for business need. So it's a really interesting development, I think, that we are going to see, and many employers that we work with do use variable hour contracts or atypical working arrangements to meet fluctuating needs in demand. Whilst you'll absolutely still be able to do that, it will mean that perhaps you'll see a bit more challenge where that's done for convenience, and actually over time individuals become settled in perhaps more predictable working patterns, and actually they might then challenge that they should be given a formalized contract. So this one as well is slightly watch this space. I'm now going to hand over to Bob, who's going to tell you a little bit about non-compete clauses.
Thanks, Alice. Morning, everyone. As Alice says, I'm going to talk to you about another proposed piece of legislation that was announced in May of this year. And then I'll move on to look at 3 cases that have caught our collective attention since our last employment webinar. So looking first at the future of non-compete clauses, in May, the Department for Business and Trade announced that it intends to introduce legislation to provide that non-compete clauses in employment contracts will be subject to a statutory cap of 3 months. That's intended to apply to contracts of employment and also worker contracts, but it won't. It currently appears that it's not intended to apply to any other kinds of employment-related agreements, such as shareholder agreements, partnership, or LLP arrangements. And I think it's probably best to say it's unclear whether it's intended to apply to other employment related contracts, such as long-term incentive plans or share schemes or deferred pay arrangements. But we'll have to see whether it's wide enough to capture those kinds of contracts as well. No legislative timescales have been announced. The government has confirmed that it will require primary legislation, so it's going to need an act of parliament to bring in, rather than being brought in through regulations under existing statute. All that the government has said so far is that it will be introduced when parliamentary time allows. And if you care to do a bit of speculating, I think it's at least possible that the current parliamentary session may end before the government actually has time to introduce this. So this is very much a watch this space brief at the moment, and it may get it on the statute books before the next election, but I think there has to be a little bit of doubt about that. So if we move on to the next slide, the couple of questions we've asked rhetorically there: what should employers do in the meantime, and can protection be achieved in another way? In terms of what you should do for now, as well as a degree of uncertainty as to when and maybe if the legislation is going to be introduced. There are a few other matters that that haven't yet been clarified in the announcement, and one of the key ones is two of the key ones are, firstly, whether it is intended that the legislation has retrospective effect. In other words, once the cap is introduced, any existing restrictions in employment contracts are subject to the cap, or whether it is intended only to apply to employment contracts entered into after the date of the legislation. We'll have to wait and see about that. And then secondly, whether the effect of the cap will be that any non-compete clauses that have a longer duration than 3 months will be limited to 3 months, or whether it is intended that they'll be void in their entirety. And because of those uncertainties, I think what employers should do in the interim is not much for now. If you wanted to be particularly cautious, you could start discussions with employers about any employees who have existing non-compete restrictions that exceed 3 months, about agreeing to amend them to 3 months so that you're future-proofing your protection against any changes that might come in. I think that it's probably a little early to be taking those steps now, seeing as we don't know some of the key mechanics of how the legislation will be implemented and what its effect will be. In terms of what protection can be achieved in other ways, again, as far as we know at the moment, it appears that this only applies to outright non-compete restrictions. And those of you who use restrictive covenants in employment contracts will be aware that the usual practice is to include a raft or a suite of different categories of protection. So though it's rare in my experience to use a non-compete clause by itself. And just a reminder, when we talk about non-compete, we're talking about a restriction on being involved, engaged, or employed in a business that competes directly with the business with which the employee was engaged on your behalf for a period after termination of employment. And as I say, you'd rarely do that alone, and you would commonly include, alongside a non-compete clause, confidentiality obligations, obligations of non-solicitation, which are aimed at preventing an employee from deliberately soliciting competing business from clients of your business with whom they've had personal contact or dealings on your behalf. You'd include, alongside non-solicitation, non-dealing, which is prohibits having competitive dealings with clients with whom the employer has dealt on your behalf. And the reason you would have a non-solicitation and a non-dealing side by side is essentially that non-solicitation, because it's so directly competitive and so clearly an abuse of the contacts that the employee has received in your employment, is probably the easiest of any kind of post-termination restriction to enforce. But it can be difficult to police, because then you can get into arguments about who contacted who, and therefore you don't normally pair it with a non-dealing clause, because the non-dealing clause targets the actual competitive dealings and isn't concerned with the act of approaching the potential client. So you'd commonly have those two together. And then you may also have other protections of your business, non-poaching of employees, for instance. In some businesses, I'd say it's become more common over maybe the last 10 years to start to protect contact with key suppliers. And as far as we know, the new legislation only targets outright non-competes, not any of the other non-solicitation, non-dealing, non-poaching restrictions that I've just mentioned. So protection can be achieved in other ways, and those are those restrictions are the key ways of enforcing them. And just to bear in mind, both before and after this legislation is introduced, there will still be the background test of enforceability that applies to any restrictive covenant. And essentially, the way the courts approach restrictions is to assume on the face of them that they are void and unenforceable as an unlawful restraint of trade, unless the employer who is seeking to rely on them can show, firstly, that it has a legitimate proprietary interest that's appropriate to protect, and those interests will include the stability of its workforce in the case of non-poaching clauses, and its client and customer base in respect of non-compete, non-solicitation, and non-dealing clauses. That part's normally quite easy to establish. And then the second limit of the test is normally the battleground when you actually get into disputes about post-termination restrictions, and that's that the protection sought is no wider than is reasonably necessary, having regard to the interests of the parties and public interest. And so even at this stage, it is possible for a restrictive covenant to not be enforced simply because it applies to too wide a scope. So an example of that would be a non-solicitation of clients clause that applies to the entire client base of the business, where an employee may have only had personal contact or dealings with 10% of those clients, and you don't limit the definition of client to those with whom they've had their own dealings, as there's no nexus between them, no unfair advantage to the employee to take in respect of most of the clients, and then you've got a non-solicitation clause that is wider than is reasonably necessary. So that's the kind of test in drafting that's applied. And then you can also simply have a restriction that a court finds is too long after the termination date to be reasonable in the context of the particular employee, their role, seniority, and what they did in your business. So all of those considerations still apply, and when you're introducing restrictive covenants at the start of employment, or when someone's role changes and they become reasonable to implement when they weren't before, you'll need to pay attention to all of those things. So that's the future of non-compete clauses. As I say, there's a great deal of uncertainty, and I think the best advice right now would be sit tight and let's see what happens next. So we'll turn to the first of our interesting cases. This is Jackson and University Hospitals of North Midlands NHS Trust. Slightly unusual case. Ms. Jackson was a specialist nurse who had a contractual entitlement to an enhanced redundancy pay if she served out her full period of notice. The trust went through a restructure, and it unilaterally changed her role from the senior specialist nurse role to a more junior role. There was a period after that variation during which her pay was protected, but after the pay protection period, her salary reduced down to the appropriate NHS spine point associated with the more junior role. And Ms. Jackson brought a grievance. Her employment then terminated before the expiry of her notice period, and she brought claims against the trust for unfair dismissal and redundancy pay and breach of contract, seeking the enhanced redundancy payment, which she didn't receive. In the employment tribunal, her claims for unfair dismissal and statutory redundancy pay were upheld, but the tribunal did not uphold the breach of contract claim, and so she appealed to the Employment Appeal Tribunal. And the EAT upheld Ms. Jackson's appeal, and it said that the trust's original intention was to continue to employ her, albeit in a more junior role. But this is the crucial point. This didn't negate the fact that Ms. Jackson had in fact been dismissed from her original position. And the EAT said that the tribunal should have considered whether Ms. Jackson's original contract of employment had been terminated and replaced by a new contract. So the question was not whether her employment in the broader sense had ended when the new contract was imposed, but rather whether the old contract had been brought to an end. And the EAT found that the original contract had indeed been terminated by the trust, and therefore it upheld the breach of contract claim, and she was entitled to the enhanced pay. Now, this is a different scenario to the fire and rehire exercise that's received a lot of negative publicity over the course of the last year, where an employer knowingly terminates a contract in order to offer new terms. This case is really about a situation where a contractual variation might be so significant that it constitutes a termination. Now, those decisions are always going to be fact specific. They're going to depend on the particular circumstances. But this case is an illustration of a situation where a contractual variation is so significant, and because Ms. Jackson's new role was significantly different in status and pay, it was capable of constituting a new contract, and her original contract had been terminated. So even though the employer didn't intend for the wider employment relationship to end, this was effectively a termination. So a slightly unusual case, and I think not one that you're going to see replicated in your own spheres of employment all that often, but it's interesting, which is why we're talking about it this morning. So the same can be said of the next case, which involves a solicitor who failed to comply with the terms of her employment contract when resigning. So Hines Solicitors and Jones involves an unusual contractual clause. So the solicitor working for Hine had signed a contract of employment which provided that she was prevented from giving notice until she had served a 3-year minimum term of employment. And the solicitor resigned in breach of the clause, and her employer made an application to the High Court for an interim injunction, initially to prevent the employee from working elsewhere until the expiry of the 3-year contractual term. But then Hine actually withdrew that application and instead sought to prevent the employee from enticing away or attempting to entice away any clients of the firm, arguing that she had committed a repudiatory breach of contract by resigning in breach of the contractual term. The breach was not accepted by the solicitor's firm, and it was seeking relief to prevent the employee breaching her implied common law duty of fidelity. And the case went to the High Court. The High Court found that the contractual term was valid and effective, so it was willing in principle to enforce an obligation not to give notice until a 3-year term had ended. But it dismissed the application for injunctive relief. And one of the issues that a court is required to consider when considering injunctive relief applications is whether there is a serious issue to be tried at a final hearing. In this case, Hine had only raised the employee's alleged breach of contract on her penultimate day at work after she had served 3 months' notice, after she'd had an exit interview, after she'd had a handover meeting, a leaving dinner, and a leaving presentation. And so in that context, the High Court said there was a serious question as to whether her alleged breach of contract had in fact been accepted by the firm when she resigned. And in respect of the employee's conduct, she had not breached the non-compete provisions in her contract, and there was no evidence she'd taken any steps to entice clients away from her former firm. And there's no serious issue to be tried relating to whether she had breached or was intending to breach the implied duty of fidelity. So there's probably, the case is quite specific on its facts again, but there's probably 2 broad points that that come out from it. The first is the importance of taking prompt action when seeking injunctive relief, and that's a point of principle that applies universally. If you have contractual restrictions that you're seeking to enforce and you don't act promptly, then that's going to cause difficulties when it comes to alleging repudiatory breaches and alleging that they've not been accepted. And the second point is really the difficulty of seeking to rely on implied duties to protect client relationships after employment has ended. The implied duty of fidelity does prevent competition, but only during employment, and seeking to rely on it in a post-termination situation is difficult, and it's much better to have express post-termination restrictions such as non-solicitation, non-dealing, if you actually want to protect those client relationships. And then our final case, again, a slightly unusual set of facts, but it's Greasley Adams and the Royal Mail Group. So the claimant here, Mr. Greasley Adams, was himself subject to the subject of two bullying and harassment complaints, which were upheld following an investigation. And during the course of the investigation, he was made aware of apparently disparaging comments that had been made about him by two colleagues. He then brought his own grievance, which was investigated but not upheld. And following his grievance not being upheld, he brought a number of tribunal claims, including a claim for harassment relating to disability. And it was accepted that the claimant, who suffers from Asperger's syndrome, is disabled in law. Most of you, I think, will be aware that harassment under the Equality Act, in order for a claim to succeed, it's necessary for there to have been unwanted conduct relating to a relevant protected characteristic, in this case disability, and the conduct has the purpose or effect of violating the claimant's dignity, creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. And in assessing whether the claim has that effect, the conduct has that effect, tribunals are required to take the claimant's perception into account alongside the other circumstances of the case and consider whether it is reasonable for the conduct to have the effect complained of. So that's the standard test for harassment in applying across the board. The interesting aspect of Mr. Greasley Adams' harassment claims is that the tribunal found that where the claimant was unaware of the conduct prior to the grievance investigation against him, he couldn't have a perception of it. And therefore, it was not possible for him to succeed in a claim in relation to the period between the comments being made and the time at which he became aware of them. So far, so sensible, I suppose. And then in respect of the period after he was made aware of the comments, the tribunal found that in the context of grievance allegations against him, it was not reasonable for the comments to have the prohibited effect. So his claim failed. He appealed to the Employment Appeal Tribunal, and the Employment Appeal Tribunal dismissed the appeal. And it said that the perception of the person complaining of harassment is a key and mandatory component, as we've just discussed, in determining whether harassment has occurred. And when he was unaware of the conduct, he could have no perception of it. So that it was not possible for him to succeed in his claim in relation to the time from the comments were made to the time he became aware of them. And in respect of the period after he was made aware of the comments, the Employment Appeal Tribunal essentially said, there's no flaw in the tribunal's reasoning here. It's a matter for the tribunal to decide, taking into account the relevant circumstances and the claimant's perception. It's done so, and it's found that it was not reasonable for the unwanted conduct to be harassment, given the context in which those comments were disclosed to him. That's a finding of fact that the tribunal was open to make. So maybe a bit of a refresher on the test that's applied in harassment cases. It is, of course, important that the complainant's perception is taken into account. I think that it's a slightly unusual one in terms of a tribunal having to deal with the issue of could it be harassment before he was aware of the claim. The answer to that appears to be resoundingly no. And that, I think, concludes the discussion on the three interesting cases. I see we've got quite a lot of questions in the Q&A, which is great. And Alice, I don't know if you've had a chance to look at any of those yet.
I have, Bob. I'll kick off quite a few of them about clarification of family-friendly changes. I'll do my best, but please feel free if you know more of the detail than me to chip in. But right. The first one is around whether maternity leave has to end before neonatal leave can be taken. I think the likelihood is that it would, so that because at the moment, obviously, you're probably all aware that you can't start and stop maternity leave. You can only use your kit days. So I think it's likely that the maternity legislation won't change, so that the neonatal leave will essentially be a bolt on to a maternity leave period, which will mean perhaps for employees that they'll have a period of unpaid potentially maternity leave before then having the paid neonatal leave at the end of that. Or we may see people bringing their maternity leave to an end more quickly, and then bolting on, say, 12 weeks of a neonatal paid leave at the end of that. But it would have to be at the end, I think, rather than part way through, which is the question. There are then a couple of questions around clarification. So apologies. There's no service requirement to be eligible for neonatal leave. So as long as your child, the newly born child, needs neonatal care for 7 days within 28 days of its birth, all employees will be eligible for it. The qualification requirement is for the pay element, so they'll only be entitled to neonatal pay, which is at the flat rate once they've got 26 weeks service, 15 weeks before the baby is born, usually, or the relevant point. So I hope that clarifies that point on the slide. The third question, yes, sorry, it was about, I think, the additional protection for redundancy for those going through the adoption process. And yes, absolutely. It's, sorry, it goes to individuals who are on maternity leave, shared parental leave, or through the adoption process. I think that's the current position and will be the extended position as well. So those have the rights, and then it's the time period that's extended. The next question is tricky. I don't know the answer to. So I know, Bob, you may know. So it's intended that the extended protection will cover those who suffer a miscarriage. And as the person who's asked the question notes, at the moment there's a legal definition of miscarriage, which is 24 weeks in, I think, rather than loss of babies earlier than that point. I'm not sure whether it will apply to the same criteria. It may do. I simply don't know. I know there was talk around employees not necessarily needing to have told their employer that they were pregnant, but then if they miscarry, they can notify their employer that they've suffered a miscarriage and will potentially have, and then would have the protection from being made redundant at that point. So I think it's probably an area that we still need a bit of refinement when we see the regulations. But Bob, I don't know if you know more than me.
No, yeah, you've summed up what I know, so I don't have anything to add, I'm afraid.
Thanks, Bob. The next one is another one around probably where the law is a bit uncertain at the moment around carers leave and where there's a policy. We'll obviously, for those of you who have our suite of documents, we'll be producing a policy in due course. No doubt ACAS will produce a policy as well, and many other providers. I think it's probably slightly too early. So although hopefully this will help you with a bit of a to-do list or to future plan the things that you'll need to be thinking about as an organisation. I think it's probably a little bit too early to have a policy on many of these things until we've got a bit more of the detail. Bob, there's one more family-friendly one which I'll cover before. I'm delighted as a non-compete one. So the next question is: will the right to ask for, to request a predictable working pattern impact on those who work remotely? Actually, I don't think it does. It's about predictability of working hours and amount of work and being offered work rather than where you work. So as far as I know, you wouldn't use that right to request to ask to work from home. Of course, the flexible working regime does cover place of work. So if someone wanted to change their location, then they would do that through the flexible working regime. Bob, the next question is around what is a non-compete clause. So actually that's interesting, assume a bit of knowledge, but do you want to just talk a little bit more about when we might see non-compete clauses and what they are and why employers use them?
Yeah, sorry if I didn't answer that question as I was going through, and perhaps I did assume a bit of knowledge. First of all, I suppose I should say non-compete clause is not a defined term. It's not something you will find in any bit of legislation with a strict definition. So it's the label that we use to describe a restriction, and you'll find non-compete clauses in a number of contexts. Most commonly, they will apply to employees of a business, or they will apply to shareholders of a company, or partners in an LLP or partnership. And partners and shareholders will find their restrictions in partnership agreements or shareholders agreements. Employees will find them in their employment contract. And non-compete specifically is a post-termination restrictive covenant signed up in, let's say, in the employment context, in the employment contract, under which the employee agrees for a defined period, well, normally during their employment and for a defined period after their employment, not to be involved in any capacity in a business which competes with the business of their current employer. So, and commonly it will simply say, you won't be employed or engaged, you won't be a shareholder or an owner, you won't be a director or a consultant or any other capacity with any business, let's say for a period of 3 months after your employment terminates, which business competes with the business that you have been involved in when you've been our employee. And often it will say in the business that you've been involved with, let's say for the period of 12 months up to the termination of your employment, so that you're keeping fresh the nature of the protected part of your business and narrowing the scope of the non-compete so that it only applies to the work that the employee has recently done for you, and therefore enhances your ability to say this restriction on them being employed by a competitor of ours only applies to doing work for businesses that compete with what that employee has done for us over the past year, for instance. So that's the non-compete. And as I say, you wouldn't normally have it by itself. You normally also have other post-termination restrictions that are about not trying to steal away customers or clients of the business for a defined period after they've been employed by you.
Thanks very much, Bob. We're going to go back to some family-friendly rights. It's a holiday pay question, which I'm going to leave to the end. I don't think we can ever do one of these webinars without having a question about holiday pay, but there's a few more on some of the family rights. So would the predictable working patterns apply to shift workers who are scheduled depending on business need? The answer to that is yes, subject to, so it won't apply. So it's about predictability. My understanding is so that actually if you have a contract for somebody and they have set hours of work, even if they're shifts, it won't apply because they've got predictable working patterns. But if actually what they've got is hours, and when they work, the shifts that they work are fluctuating or aren't predictable, then it would engage. That's my understanding. Bob, do you agree with that? Yeah, I think so. There's a couple more about neonatal care. Yes, both parents are potentially entitled to 12 weeks leave, and if they had 6 months service, they would also then be entitled to statutory neonatal pay as well. They wouldn't, I think it's a separate and distinct right, so each parent is entitled to it. So unlike shared parental leave, where both parents need to be eligible for a parent to invoke the right, as a parent, you would have the right to 12 weeks neonatal care if you wanted to use it. So both could use it or just one, and the same, either parent. So only if one is only working, one of them would just need 6 months service, 15 weeks before the relevant date to get neonatal pay. Is the neonatal care linked to how long the child is in hospital? Actually, that's a really good question. That doesn't appear to be the case. I think that would probably be unduly complicated. It appears that it's going to work that as long as a child is in hospital for 7 days, continuous uninterrupted 7 days, then that will trigger the entitlement to neonatal leave. I think we'll see some detail in the regulations about what uninterrupted means, and if a child's in and out of care over a period of time, it's likely still to be caught. But it's not a proportionate thing. So actually, if the child's only in for a week, it doesn't mean that you only get a week. 12 weeks is once it's triggered, you get the full amount. But it would be up to parents. They don't need to take the full 12 weeks. But they can take between 1 and 12 weeks. That's my understanding of how it's likely to work. Bob, chip in if you disagree. There's one more about neonatal care, there's a few more about neonatal care. I'll try and group them together to help. So how is neonatal care defined? What if the baby requires care in hospital so that neonatal care kicks in, but then baby can leave during the mother's maternity leave period? Yes, as that's where if they are in hospital within the first 28 days of the baby's life for at least a period of 7 days, then they're entitled to the neonatal leave. So actually, if they've just need 1 week in intensive care or 2 weeks in intensive care, mum would still potentially get her 12 months maternity leave, which would start, and then the 12 weeks on top of that. And then will lots of, I don't know all the detail of the neonate, will they have required to have proof that their baby has been in a neonatal unit for them to take the leave? I think it's unlikely that you'll need to have proof. Most family friendly rights at the moment are self-certified. I anticipate that it will be a similar process, but we simply don't have the detail of that. It's certainly been commented that initially when a child's first in hospital, or there will be an initial notice to the employer, which will be very, very light touch. So I don't think there'll be any forms or anything required, but it's just an early flag, and then there'll be a more formal notification when you go to invoke the leave. So it's possible there'll be some medical evidence at that point, but I think that would be inconsistent generally with how family leave rights work at the moment. So so I would guess not, but I don't know for certain. And so the 26-week service is to engage the right. So it's 26 weeks before, 15 weeks before the baby is due, is the 26-week service. So it doesn't matter how long maternity leave takes, it's before that. It's triggered for the pay if they've got 26-week service 15 weeks before the baby is born. So it's the same trigger you'll be familiar with as statutory entitlement to statutory maternity pay. It's the same trigger to be entitled to statutory neonatal pay as well. I think I've done all the neonatal ones. Bob, there's 2 about non-compete. Well, one about the case, yes, and one about non-compete. Do you want to pick those up?
Yeah, so the one about the case says, regarding the last case illustrated, I think it's meant to say, what if the claimant's conduct is by common sense offensive, or it should be given their role in the organisation. Common sense is a tricky concept, I think, sometimes in the relation to harassment allegations, because context is incredibly important, and the reasonable perception of a claimant has to be assessed. And so one person's common sense offensive might not be the same as another's. And what an employment tribunal panel does when considering a harassment claim is it considers the claimant's evidence as to what they found offensive and why. And obviously, in terms of offensive, we're only talking about harassment in the context of the statutory definition as it applies to a particular protected characteristic. So we're not talking about harassment other than in the context of protected characteristics here. And the tribunal uses its industrial background and knowledge of the working world to decide whether that person's perceptions of offence are reasonable in the context. So, for instance, there was a case a few years ago involving a claim of harassment by an employee who was a member of the traveller community and had been subject to slurs based on that ethnic background. But and it was accepted that the comment had been made, but the tribunal found it wasn't harassment because this particular employee routinely said far worse things to his colleagues and robustly participated in a fairly uncouth workplace culture, and what would have been definitely an act of harassment in another workplace aimed at another employee, in this particular individual's case, was determined not to be harassment. So you do have to always consider context. And then there was one other question.
About whether a non-compete can apply to
An ex-trustee.
trustees.
That's the kind of question that we might actually need to speak to colleagues of ours in our
Yeah.
charities or corporate teams, because Alice and I deal with the employment relationship. Um, I mentioned shareholders and directors, and they are often people who wear multiple hats and are employees as well as being shareholders and directors. So we come across those more often. I'm not sure that I've ever actually had to advise on restrictive covenants applying to trustees. So the best I can do is apply a bit of logic to it, and say trustees do often sign up to obligations of confidentiality, which is itself a type of restriction. So as a matter of principle, it may well be that a non-compete or other kind of restriction could be applied. Also, consultants are sometimes asked to sign up to restrictive covenants, and sometimes that might be a factor that weighs into an argument about whether they're genuinely consultants or not. But if restrictive covenant injunction claims are brought against consultants who have such restrictions, the courts apply the same tests that they apply to employment contracts, i.e., is there a legitimate proprietary interest being protected by this restriction? And is the restriction no wider than is reasonably necessary to protect that proprietary interest? I can see that trustees may have access to information which would enable them to have an unfair ability to compete with the institution of which they were formerly a trustee. So my best guess on matters of principle is that I could see an argument for including such restrictions in certain trustees' contracts if they're in operating in the world, the business world, or the working world of the institution for whom they're a trustee. But that comes with a fairly strong caveat that I'm an employment lawyer and don't routinely advise on this. So if you really wanted to know, you should drop us a line and we'll introduce you to a colleague in the corporate and charities team who can definitely tell you.
Yeah, we better crack on, but it is really interesting question. And of course, you might choose to put them in your kind of guide, if you've got any sort of contractual agreement with trustees, you could include them even if they weren't enforceable. No, but to help manage behaviours potentially, you might think about it. A couple of final last questions. When do we expect the right to request predictable working to come into force? I'm really sorry, I did look for that. I don't think we've got any date. I think lots of these are likely to be, between spring 24 and summer 25, but obviously we'll probably have an election in the gap, so we'll see. Is there any update, finally, is the last question, on the Brazil holiday case? Well, can't go into the detail of Brazil, but those of you will know that it concluded that part-year workers and casual workers were all entitled to 5.6 weeks of paid holiday at their normal week's pay. That's the current law. We've got 2 consultations out at the moment that would potentially change that. One directly by the government as a result of the Brazil judgment, and one as a result of Brexit, and with the working time regulations being identified as an area where they weren't particularly user-friendly for employers. So we are going to see change, but again, we've got no idea of timeline. We've rattled through everything. Thanks so much for your questions. It's really interesting. I hope you have enjoyed it. Please do get in touch with us if we haven't answered your question, or if you need more detail on any of this. Thank you for completing the poll that Ellie put on screen. We're always interested. If you've got any topics that you'd like us to cover in this webinar program, please let us know. We will be sending you a copy of the slides and the recording, so you've got them, can share them with colleagues or refer to them. And you'll know we also have some e-learning, so we'll be sending you some details about that as well. And if there's anything that you want developed in order to train individuals in your organisation who have got HR responsibilities, or some of them, Bob was talking about harassment, we've got some on the way to help manage harassment in the workplace as well. So just to let you know that that's on its way. But otherwise, well, thank you for attending, and hope to see you again soon.
Thanks, everybody.